A very good evening, ladies and gentlemen of the audience. My name is Jasminda Kaur, and I represent the School of Business as well as APU's enterprise team. Without further ado, please allow me to introduce our speaker for this CEO CTO series session. Ms. Paramjit Kaur, affectionately known as Pam, graduated from Keele University, UK, with a bachelor's honours in law and economics and was subsequently called to the Malaysian bar. She has been active in litigation and a partner in a Malaysian-based law firm. She has had experience as legal counsel in M Investment Bank, now M Bank Group, handling corporate banking and corporate finance advisory, apart from other investment work, together with litigation advisory. She later became the Chief Legal Officer of Total Sports Asia Group of Companies, advising on their global business relating to media license distribution, sports-related events management, sponsorships, etc. After 13 years at Total Sports Asia, she moved back to the financial industry and joined CIMB Principal Asset Management Berhad as the head of legal ASEAN. In early 2019, she set up the corporate secretarial unit within legal itself, was then designated as head of legal and corporate secretarial ASEAN. The company has since undergone a realignment of shareholding and a rebranding exercise in Malaysia. It is now known as Principal Asset Management Berhad. In short, I see her as a firm beacon of the Book of Law. She will now share with us pivotal advice on advising commercial and intellectual property issues currently faced. Ladies and gentlemen of the audience, please be advised that we welcome you to share your questions through YouTube and Facebook links respectively, but we will only address them during the question and answer session. So if I may roll into the session, Pam, perhaps we could take this opportunity to share a bit about your background and how you came to be involved in the areas of commerce and intellectual property.
Hello, everyone, and good afternoon. Thank you for having me here today and to allow me to share a little bit about what I know and to answer whatever questions that you might have. My background is a lot of what you've already mentioned, and basically I studied law and economics at Keele University, and I completed my CLP, and I proceeded to be called to the bar, and I was a litigator for about 6 years plus, and a lot of how I got involved into commerce and IP is is also based on the background of my jobs that I've had. So as a litigator with Messrs. Sriram & Co., I did a lot of suits relating to commerce and IP, but not so much IP. It's more commerce and banking, right? The firm did a lot of IP, but I personally was involved in commerce and banking litigation. And after a couple of years there, I moved to another law firm, and I was still involved in commerce and banking. And I think after I'd spent a total of 6 years as a litigator, I decided to move on to M Investment Bank. I spent 5 glorious years there. It was very interesting for me because it was also the era of e-banking and alliances. That was the time when they started to make payments electronically using internet, but then only via a credit card, right? It was still not dipping into the bank accounts yet. But that was the very start. And with that, there was a lot of alliances that were formed, where, for instance, Petronas might want to have their logo onto credit cards issued by a local bank. So that kind of alliances were cropping up everywhere, mushrooming. And it was a very interesting time because that's where commerce really married IP, right? So I spent 5 years there, and then I got back to practice for a little while as a partner in a law firm. And then I decided to go back in-house, and I was with a sports marketing company. This was a job that I truly enjoyed because I've always enjoyed sports, and sports is where total sports was where there was a lot of transactions. So a bit of background about total sports, which also shows you how much of IP experience I've had. Total Sports was a sports marketing company. And when they first started, about 8 years before I came in, they had their own, they had the rights from WWE wrestling to sell their media rights in Asia, right? So they sold their media rights in Asia, which meant that they would tie up with the RTMs of Asia, right? So in Malaysia, they went to RTM and said, "We've got the rights to WWE. Would you be interested?" And if RTM says, "Yes, they've got quite a following, I want to do this," then RTM would sign up a license agreement with the help of Total Sports Asia, and they would then, get a license for, say, 1 year or 2 years, depending on how many years they wanted, and that was a commercial transaction. But what they were really getting is the IP rights to the media footage of their events. So that meant that they could, for the duration of the license given to them, run the WWE events, but the terms and conditions were very specific. How many times a week were they allowed to air, and for exactly how long, how much would RTM pay for these rights, right? And things like that. And I think at the time that they brought me in, they decided, the CEO decided that he wanted to go bigger than that, right? So before I came in, they could rely on just template agreements. And whatever, for instance, RTM wanted, they would put the key terms like the name of RTM in full and the details of payment. And they would put that into a template agreement. And that template agreement would be viewed by the lawyers of WWE. So Total Sports Asia themselves, they didn't at that point need a lawyer. But when they decided they were going to grow bigger and do other things besides WWE, that's when they decided that, very rightly so, that they needed a lawyer in-house. So they called me in, and I was very excited about this job. I came in to set up their legal department, which for a year or two was just me. So I handled, so at that same time, they decided to get other rights, right? Like BWF, US Open, and things like that. And so we got very busy. We got very busy indeed. And soon I had more lawyers joining me, and we were a full-fledged legal department. So apart from growing, getting more media rights to distribute across Asia, they also then decided that they wanted to hold events, and they wanted to get sponsorship for events. And that's where sponsorship is basically using someone's IP or name, right? And marketing it to other companies who are willing to pay for it, right? So I don't know if some of you saw Ryan Giggs' poster, in Isetan many, many years ago. It was a huge billboard. I think it was Rolex that he was advertising at that time. So that was a deal that we would have brought together. And that was in several territories. Right? So Total Sports Asia was a very, very interesting job for me. It was also Total Sports Asia where after a few years they decided that, they wanted to have, they wanted to create their own WWE-like event. So what they then did was they brainstormed and said, okay, I think kickboxing is the way to go. There's a growing interest in that sports. So they decided to do a startup, right, out of Singapore, not even Malaysia. So then they had to think, okay, we want to have a startup. This is what we want to do. And a lot of thought went into a business plan, right? So they decided, okay, they had to plan everything, right? From where are they going to get the fighters? Where are they going to hold these events? Are they going to create a media footage out of these events and market it? Where would they market it? right? So for this kind of a business, IP is really, really important. As you can imagine for WWE, how important IP was. Right. So then, we had to also plan out where we were going to hold events, where we were going to broadcast, where were we going to file for IP rights first, because filing for IP rights is very important. So that's where commerce and IP really was very, very useful and very prominent in my work. From there, then I decided after 13 years, I felt that it was a long, long time, and I wanted to go back to finance. So that's when I arrived back with in the financial world, and I joined CIB Principal, which then had they had some realignment so that CIB was no longer a major shareholder. Principal was, and therefore we had to do rebranding, and IP was again prominent in my work, where we had to make sure that all these things are registered here, because we had a new logo, company logo and trademark. So that's a little bit about how I ended up, a bit about my background and how I ended up doing commerce and IP.
That's very interesting, Pam. And given your diverse exposure in terms of working experience, if we were to actually break it down further and advise our students, what would be the key advice that you give our students that is really, really important for them to take note of where this marriage of commerce and IP is concerned?
Yeah, at the end of the day, if you think about it, everything you do involves commercial transactions, right? From the cup of coffee you buy in the morning, like if it's Starbucks, you've got a huge Starbucks logo, right?
That's
To
right.
running a business, whether of your employer, of your own, you have to remember that the most important asset of a company or of a business is the logo, right? If you don't protect that logo, the value might be affected. You might lose, your rights to the logo if someone else comes in first and protects their logo, which looks similar to yours, and things like that. So if someone actually copies your logo and your customers are misled, that might the profits you might lose profits, because your clientele might go there, right? And you might lose business goodwill, and that is also why we have very stringent IP laws. So I would actually advise students to look very closely on what type of business you have. Is IP important to you? Is it important you have a logo? How you market it? And IP, as you know, has got three components. You've got the copyright component, which is what you reduce to writing, like books, music. Then you have patents, which involves inventions. For example, if you had invented the telephone and you don't want anyone else to, invent and take credit for it, you would, register that as well. And I guess the most common is the trademark. Uh, Most businesses have a trademark. You have word marks. That means it's not a picture, but it's just the word. You also have slogans and phrases. For instance, gardenia. Every time I see gardenia, I have that visions of so good you can eat it on its own. You've seen that in advertisements.
Yes.
And for instance, Mercedes, you've got the best or nothing. These are like slogans, phrases that you can also trademark, right? So protection in terms of filing for IP rights, protection is as good a sword as it is a shield. When you register your IP, you're ensuring that others don't encroach on your rights. So they cannot use your IP, they cannot use something similar. Right? And by the very act of registration, what actually the process is that the person registering your trademark for you will also need to do a search to make sure that there's no other logo that already is registered that is similar to what you want to register, right? So if you already know there's a logo similar to yours and you're registering it later, you might want to go back to the drawing board and change it a little bit, right? So that you don't transgress on other people's rights either, right? So when you file for registrations, what that happens is, what it allows you to do is that you can search other logos and make sure that there's no transgression. In relation to commerce, I think if you're running any business, you have to have very clear procedures and terms and conditions of service, right? What exactly are your products? What is your customer going to receive? That has to be very clear. right? So there's no mistake on the customer's part or your part, and so that he is willing to, accept your product and pay for you. And if your terms and conditions are very clear, then if he doesn't pay after receiving your products and service, then you can sue and claim for it, right? So I think those are the, and where there's a doubt, always get advice of lawyers.
That is indeed right. I would definitely agree with that. At the same time, most of the time, these young entrepreneurs, they pretty much are starting out, and they may require financial backing. They may not necessarily have that financial foundation that is, broad, um, like in the sense if we compare with the company. So, along those lines, would it be then safe to say that if they're going to step into the realm of protecting their ideas or whichever asset it is, or they are, they are what they are known for, recognized for, that they are likely to start out with applying for a trademark? Would that be something that is safe to advise them on?
Yeah, I think if you're starting out, always have your trademark. If you're going to use, if you already have a logo ready, make sure you register it first. That's the safest option, because, like I said, it's not just a sword; it's also a shield, right?
Mhm.
You make sure that no one uses your trademark and steals your clientele and goodwill, and at the same time, you also make sure you're not breaking the law, because it can be very costly if you are
Right.
sued
Yes.
for the usage, right?
That's right. And along those lines, when you also mentioned that it is very important that there are commercial based terms that are also drafted or put in place to further enhance the protection. So, would it again be a strategic move for young entrepreneurs to actually do market validation first, run that, and then identify who their target market is, what is the need, the pricing, and everything, and then work about drafting commercial based terms? Would that be
Definitely.
okay?
Definitely. I mean, that's a given, right? If you want to start a business, you have to do your background check and, be clear on your business plan and everything. And once you're certain how you're going to, what product you're going to sell or what service you're going to deliver, how you're going to deliver it, all these things are going to be required for you to actually get the terms and conditions side of things clear. So if you have a lawyer drafting that for you, they will need to know all that before they can come up with very clear terms for you to use for your business.
Okay. And along those lines, because Pam, you have emphasized a number of times the importance of there being a presence of a lawyer or a legal advisor to help with the drafting and help with the protection and things like that. But if I may say, we are now in the realm where Google seems to be the go-to for every single thing, whether it's medical advice or it's even legal advice for that matter. So, if we did have students who decided to be creative and decided to come up with their own form of terms and conditions, would that be something that's acceptable?
If they are fairly certain that they won't get into any trouble, for
Mm-hmm.
sure, because there are definitely templates you can find outside, right? But it's also a matter of how complicated your product or business is. If for instance, in the case of Total Sports Asia before, I did say that they had a template, but that template was definitely reviewed and drafted by in-house lawyers of WWE, and they were fairly certain all you needed to input was the name of the client who was going to buy these rights, how much they were going to pay, what duration. The rest of the terms are standard, and WWE was very strict. Nothing is going to change. Then, uh, that's very clear, right? So if you're going to do something similar, you can copy their terms and conditions and change a bit here and there and say, okay, this is how I want to do my business. But largely, when you get into other certain types of businesses, it's not so simple as just having one set of rules, right?
Mm.
So that's where I think, if you are relying on something that's just taken off the computer, the internet, it may not be totally sufficient to cover you.
Okay.
So it's always safest. I mean, I understand as a startup, you're trying to keep costs down and everything
Yes,
low.
that's right. Be
But I
cost
think
effective.
a stitch in time definitely saves nine, right?
Yes.
Especially in the case of legal issues, it would be advisable for you to see a lawyer in a law firm and say, this is what I want to do. These are the terms and conditions I'm thinking of. Can you please have a look through and see whether is this sufficient to protect me? And you have to give him all the information that is what he might need to rely on, and then he would give you one set and say, okay, based on your business plan, you just need this as a template, and you just need to change that, and off you go. But if you're doing an events management business, for instance, no two events are going to be the same, right? So it's going to be very difficult for you to take a set of terms and just go with it.
Okay, that's a very important point to note then. We still have to craft and draft it according to the specifications of our product or service that we're providing. Very well then.
Correct.
So moving along from there, you shared with us about WWE. Perhaps you could share further any other success stories or examples of success stories that have taken place, as well as a failed story, so that our students also have the opportunity to draw a comparison of whether they are moving along the right path, or if there's further room for improvement or development to ensure that they don't fall within the bracket of becoming a failed story. So perhaps you could share a little bit
Well,
about
there are
that.
many, there are many stories when it comes to what I've just spoken about. For instance, if you have IP rights that are not protected. So I told you about the kickboxing events that we started. So
Yes.
it grew very fast and very quickly, and then we decided that we were going to hold an event in I think it was Netherlands, where our IP rights had already been filed and protected and everything was great. And then at the last minute, there was some complications, and we had to quickly switch to Turkey, I think it was. And we had very little time. And whilst the legal department was waiting for the go ahead to register the IP in Turkey, because they were all so busy running the nitty gritties of holding that event in Turkey, someone in Turkey, a local person, went in and quickly registered that our logo
Oh dear.
under his name. But I think he had switched it a little bit, right? And so what had happened was that he had put in the registration, and then while we were starting out our marketing, he coolly wrote and said, "Hey guys, by the way, I have the IP rights, and you shouldn't be using this, blah blah blah." And he had already known that it was a month away from the event, and that it's very little we could have done. So in a case like this, because we didn't register in time, someone had gone and done it. Of course, you could have taken him to court, but it would have taken way too long, right? So
Yes.
then, we did the next best thing. We sent our most efficient director over to speak to this person who was an individual and negotiate with him to say, look, can you sell me the IP rights? Because I need to run an event. And of course, it was up and to and fro. And finally, they agreed on a figure and went to a legal office straight away, drafted the contract, paid him, he signed, and then we managed to have our event in Turkey. Um,
So that was a really
you know,
close call.
that was a really close call. And we also had a situation where, the sports marketing company that was in Total Sports Asia was trying to also register their logo over here. And then they realized that, there was a similar named sports marketing company in the US that had already pre-registered, right? So if they had gone and started using it without trying to register, they would have breached this person's, rights. And so they found out also that this company actually was not doing any business here, but they had filed this thing here in Malaysia like a long, long time ago. So in law, you also have this thing called squatting on your rights, where you think someone's going to register or one day hold the event, and then, they want to just register in Malaysia but not do anything. In the end, there was a huge legal battle trying to get them to remove. But I think before the long story could end, that company in the US went bust. So I guess, we were lucky in that sense that we didn't have to go all the way fighting, because that can be very costly. So again, a stitch in time saves nine. Just see a lawyer, get your plan ready and thought out, and just get
And don't chase
advice first.
Yeah, I guess don't take the protection for granted then as well. Don't say I have time. The minute that you have access to it and so forth, just go forth and get it protected. I suppose that's what the main bottom line would be. So
Yeah,
if
and
let's
there's also a case of, I don't know if you all have heard a very interesting case where McDonald's came down very hard because there was an Indian restaurant called McCurry. I don't know whether you've heard of that. So McCurry is an MC
interesting one.
Curry,
Yeah.
Curry, right?
Yes.
So McDonald's said, no, you can't use MC in front of your curry because we have the rights to the prefix Mac, MC.
Mm-hmm.
So there was another huge battle, and these poor guys had to go to court. It was just a small Indian restaurant at that time, I believe. And they had to
Mm-hmm.
go to court because McDonald's was not going to let them get away. And they insisted, we want to use this name because they already had goodwill. And so at the High Court, McDonald's actually won. But I think later on, at the Court of Appeal stage, Court of Appeal didn't agree. They said,
Right.
look, this is a curry house, right?
Yes.
You are
Yes.
McDonald's, it's totally different,
Right.
right?
Yes. That's right.
Yeah. So I think at Court of Appeal, they didn't succeed. And then they tried to go to the federal court, but the federal court
Mm-hmm.
didn't give them leave to appeal because they said, you don't have a case, don't even try. So that's
When
how it
McDonald's
ended.
when McDonald's actually brought forth the case, was it because this MC that was being used, was it the same font? Was it the same color? Was it the same sort of outlook that
It
made
was
them
the same
decide?
color. It was the same
Right,
color, but the logo was not, I don't think there was much similarity. They were just
Okay,
relying on the MC basically, right?
right. So in that kind of circumstance, there's also a possibility that the courts will differentiate the two logos and also
Yeah,
see
but
the kind of products that are being served or being provided uh, to actually understand if there is some form of infringement or not.
yeah, there's a lot of principles that they have to review and look at. IP law is very, very deep, as you can imagine.
Yes.
But the point is that they had to go to court and spend a lot of money. Lawyers are not cheap. We all know that, right? Litigation
Hence
is
the
just not cheap.
that's right. That's right. Litigation is not. Yeah. Hence the reason why I asked the question. Like our students would definitely be worried about that first because the perception always is law is expensive, and so
Again, stitch in
what's the
time,
best?
right?
Yes, that's right.
Yeah,
That's right.
it's always I mean, until you're big enough to have your own in-house lawyer and slowly an in-house team, it's really important to get the advice early on.
Okay. All right. So that's also another very important or a cardinal key point that we ought to take into account. Now, moving forward
Absolutely.
from there, now that we are in the digital transformation era,
Yeah.
what have you noticed as emerging themes in regards to IP that entrepreneurs should be further mindful of?
The only difference with digital transformation is that commercial transactions are taking place at a faster speed and across
Mhm.
boundaries. So it's basically the same issues, and I think the same IP protection is required. It's just that you might, because you're now able to transact in other countries, you might want to get advice whether you need to register there and
Hmm.
how you register, what you register, all that is very important. It's basically a faster world, right? So issues need to be resolved fast as well. And if you're that big that you are, mushrooming across globally, then you really need an in-house team to make sure that, not only that you start out right, that all issues are, resolved as quickly as possible.
Okay. All right.
I know I seem to be marketing lawyers, but I'm not in practice anymore. So I don't stand to benefit from this.
No, but you're setting it right because, like you said, like you rightfully said, you've got to get it right from the very outset. If you don't get it right from the very outset, then you are always going to be struggling, and then you're always going to try doing course corrective measures, which is eventually going to really be very costly for you. So perhaps a little investment where this legal realm is concerned would be a definite must.
Yeah, I think when you're doing your business plan, the financial plan is equally important. And when you're looking at finance, always make that, put a little bit aside to get yourself legally cleared.
Okay, all right. So with that in mind, since we are speaking about this, and also we are understanding the perception that our students may have, or these young individuals may have, the thing that I would like to definitely share is generically when students tend to hear the word law, they experience a brain freeze, or a complete block. So, being somebody who has been in the legal fraternity and being somebody who has been exposed to these diverse corporate sectors, how would you break down the reality to them where law is concerned?
When a legal issue arises, keep calm and call a lawyer. Always ask for help.
Oh,
Don't ignore a problem. Like I said, you really need to act fast, because sometimes you can reduce your cost very much by acting fast. For instance, someone sends you a letter of demand, you're like, oh my God, I'm in trouble. Actually, you might have a very good answer to it, but if you keep ignoring it and putting it at the bottom of your drawer, closing your drawer, in fact locking it and throwing away your key so you never have to see the letter again, that guy, if the amount is big enough for him, or the issue is important enough for him, he might go to court, right? And then you have to appoint a lawyer and do all these things. Whereas, if you've just taken that letter and gone to a law firm and said, or any lawyer, who's able to advise you, and say, I've got this letter, what do I do? He will just, help you sort your problem out and say, oh, actually, this is a very simple matter. Ask you a couple of questions, draft the letter for you and send it back. And then he's going to know, oh, okay, these guys have got lawyers. Maybe I won't waste my money, because it's not going to be an easy win for me, right? Uh, because if it's an easy win, it's just filing a claim, no one appears in court, I get judgment in default, and I go home, I've got a judgment. But if I'm going to file something and my opponents are actually going to get lawyers, and there's going to be a fight in court, it's going to prolong, I may not want to proceed, because I know I'll have to spend even more money on my lawyers, right? Than the money that I've already spent on the legal letter. So yeah, don't be afraid of lawyers. Don't be afraid of legal issues. It's just part and parcel of business. You need to handle these things, which is why planning is very important. Getting your terms and conditions right from the start, so that your customers know very well, I'm getting this product, I will have to pay. There's no way I'm going to be able to run away from it. I shouldn't even try. Like I said, a stitch in time will save nine, definitely.
so one thing that you also did mention, Pam, is that whenever there is any form of issue, the redress should happen in the court process.
Not
Is that
necessarily. Not necessarily.
it?
Sorry, your question is not complete.
So I just wondered along the lines of arbitration, because arbitration happens to be the alternative dispute resolution method that we do share with our students, or we do have fast becoming something that is popular. So where IP is concerned, or where any form of commercial concern is there, would you recommend students to even consider, or young entrepreneurs to consider arbitration to resolve these kind of matters?
Okay, so traditionally we used to say that going to court is faster. Going to arbitration is faster, because the court process is quite long. Nowadays, even arbitration takes a long time. Um, with arbitration, it can get very expensive though, right? Because you are paying the lawyer who's representing you, and you're also paying the arbitrator to sit there and decide on this
Right.
dispute, right? And if of course, you're supposed to share it with your opponent, but if your opponent doesn't pay, it's going to land on your head. You also have to pay for the venue, rental, and things like that. Whereas for litigation, you don't need to. Yeah, for litigation, you only pay your lawyer. No, you don't have to pay for the judge's salary. You don't have to
Yes,
pay
yes.
for using the courts. So what they do sometimes, because I think there's great value in trying to settle a case, right? Either where you're never going to win, or you think I'll win eventually after 10 years, but this thing can, after high court, they can appeal and can go on and it goes on forever, and I just want to put this behind me. You come to a settlement. So either you reach out to their lawyer and settle it, and just meet halfway and just say, okay, let's not waste any more time and money on lawyers. Or, after filing, there's a third way of sorting this out is through mediation. So these days they look at litigation, they look at arbitration, they look at mediation as well.
Interesting. Interesting.
So with mediation, what you're doing is you're trying to come to a settlement, and then you file a settlement agreement. You sign a settlement agreement. Again, settlement agreements have to be drafted by lawyers, right? Because there are a lot of things in there you got to cover yourselves. Because the last thing you want is you settle at 50%, you've paid the 50%, and they come after you for another 50, right? So the terms and conditions of the settlement agreements are very, very important.
Very important.
And once you settle, the terms are clear, and you sign off, whoever needs to pay pays, and that's the end of the matter. You don't have to wait 10 years for this thing to go round and round.
Okay.
Court of first instance might be the high court because of the value, and then there's an appeal to the court of appeal, and then the party who loses can still go to the federal court. So there's just many steps to go.
Okay, and that's what pretty much makes it very time consuming, as you mentioned. So
And costly.
And costly, that's right. And very costly. So along those lines, I mean, in regards to stepping into the realm of intellectual property, being aware of drafting ironclad, if I may say, terms and conditions, and being aware of when is the right time, the right place, and the right mode of going about gaining protection. Would you say that these are the themes that are also applicable for international boundaries? Since
Yeah.
we have students that are Malaysian, we have students that are international, and naturally a question that will come to them is, okay, this is the way we move, or the groove in Malaysia, is it the same overseas? What would be your take on that?
Okay, on the commercial front, you have to be aware that there are different law countries have different laws, right? So it's always best to get the opinion of lawyers who are from the country where you're going to do your business, and I mean, business plans and financial plans, all that could be the same. But when it comes to commercial issues, then you need to know that the laws could be different. For IP, there's a bit more consistency because you've got the NIS classification, meaning that the classes of registration that you can do for your products is standard across, right? So for IP, there's a little bit more consistency, but still, if you're going to market it in let's say you have products and you want to market it in the UK, either you get a lawyer here who will definitely need to consult a lawyer in the UK, or you just go direct and get a lawyer in the UK to say, yes, this is fine, we've done the search over here, and you're not going to transgress anyone's rights. Go ahead and you can file, and we can file it for you. So it's always best that you clear the legalities of the country in which you're going to carry out your business in.
So to seek clarification in that regard, if let's say, for example, I've started a business here in Malaysia, and then I decide to penetrate the markets in the UK, would that mean that I not only have to ensure that I have myself covered with the governing laws of Malaysia, but I would also have to ensure that I have myself covered by the governing laws of UK as long as my products are in the UK market?
Absolutely.
Okay.
Absolutely,
All right.
because you might not be foul of the laws here, but you might run foul of the laws over there, and you don't want that. UK is even more costly than Malaysia.
Yes, that is true. That is true. But what is actually important is that we can't just take it for granted that it's acceptable to only be protected or have a governing law of the country that I do business in, but also to ensure that any others that products that penetrate any other market, their governing laws too have to be adhered to as well.
Yeah, and in some cases, when you breach the laws, it can have severe reputational damage too, right? People hear about it, and then they start to have doubts about, the credibility of your company, your products, your services. So you really don't want to go down that road.
is there some way in which we can synchronize it? Because we've got concepts like international law or even free movement of goods. Is there some way in which we can actually synchronize our outlook towards these governing laws in the long run?
Uh, it would really depend on where you're doing your business and what the laws there are and how much they differ from your laws here. And, like I said, you would need to get a lawyer's advice.
Advice on that.
Yeah,
Okay.
they might be able to synchronize it for you quite easily
Mhm.
because they've been doing business in both jurisdictions. But yeah, they are the experts. You need to get that advice and clearance.
Okay. All right. So moving along from there, Pam, what do you think is likely to change 5 years from now, where commerce and IP matters are concerned?
Well, they keep saying that AI is going to take over. We won't need lawyers. We won't need doctors.
Yes, yes, I've
We won't need
also heard that.
anyone. But like I said earlier when you asked me that question, yeah, you can go to Google and download a template of contracts, but you still need someone to hear you out, think for you, and come up with a set of terms and conditions that you can use for your business, right? So I really don't think that the lawyers are going anywhere, as much as they are so hated most of the time. But they're
Yes,
not really
yes.
going anywhere. You're still going to
Okay,
need them just as much as you're going to need a doctor to hear you out when you say, "Oh, doctor, I've got this pain, that pain, this is bleeding, and that's exploding." You're still going to need these people. So I do not anticipate that anything is going to change unless we're going to become robots.
hmm.
And even then, I don't think.
Because
That's
that
my
is
short
something like,
answer.
that's your short answer. Okay. So everything is expected to remain at status quo in the next 5 years. Would that be
That's
a good
that's
thing?
what I anticipate. Would that be a good thing? I think it's good to learn from mistakes already made by people, and if there are going to be new ways of doing things, and there'll be new mistakes that are being created, and then you have to slowly discover that it might be a bit painful. If I'm doing a business, I'd rather find out what everyone else has done wrong and make sure then that I'm starting out on a good foot.
Okay. All right. So nothing actually beats the human touch. And
Yeah.
again, if you want to make it and you want to make it big, where the entrepreneurial setting is concerned, you've got to be prepared to make mistakes and learn from them.
Yeah, definitely. I mean, mistakes will happen anyway, but you don't want to make all the mistakes yourself. I would like to think that you want to, learn from others who have made 90% of the mistakes, and then you can say, okay, this 10% couldn't be avoided.
Okay. Interesting. And I suppose at the end of the day, you would also still always have to keep track of what your competitors are doing and always
Yeah.
continue to evolve.
Yes. So, change could be a good thing, but
Mhm.
it depends on, how you're going to land going forward.
Okay, so Pam, if I may sum up, basically, your key advice to our students and to our young entrepreneurs, pretty much, whether we like it or not, commerce and intellectual property are married to each other and till death do they part. And of course, sponsorship is very, very important. Where the asset of a company is concerned, you're looking at a logo, and it is super, super crucial to make sure that you register it on the spot or at the right time, because you don't want to end up losing profits. um, Also depends on the type of business that you're running, what you would wish to market, because then you would identify very clearly the kind of protection that is suitable for your product. And along those lines, yes, IP protection is like a shield, it's a sword at the same time. So it's very important to do your groundwork, make sure you do market validation, so that even the commercial base terms that you identify are ironclad for your business. And a common pitfall is taking these ideas for granted and not actually protecting them in time. And also, because you are someone who is a novice, you tend to, in the process of taking things for granted, end up being in a situation where somebody could be squatting on your uh,
Rights.
rights, basically. So it's always important to not only try and be cost effective, but you've also got to be time effective as well. And where the law is concerned, have no fear. If you're going to have to fight your rights, you're going to have to do it right. Besides the court process, mediation seems to be an emerging theme or solution that one can actually use. AI is likely to take over, but as long as the human touch is there, it is a lot of things are going to remain as status quo. So that is pretty much your take on how we're going to deal with commerce as well as intellectual property issues. Am I right, Pam?
Absolutely, you've done a very good job of
Oh,
summarizing
thank
everything
you.
I said.
All right.
Yeah,
Thank
that's
you.
the long and short of it. Of course, there are exceptions to everything. Yeah.
That's right. That's
And
right.
yeah, lawyers really, I don't know why they are hated so much, but they're really friendly people.
Okay, guys, you've heard that. You've heard that from Miss Paramjit herself that we are
Yeah.
very friendly people, and
Do your
definitely
research. Do your research. Find the most friendly lawyer, and start talking to them. You'll get a lot of advice.
that is very true. Actually, I would definitely second that. And of course, another very important thing is that lawyers are here to always help you be aware of what you should do, what you shouldn't do, and how you can go about best addressing matters. So, with that, Pam, we will now open the floor to question and answers, and we've got quite a few that have come in from our students. So, I'm going to jump right in and start reading some of the questions that we have. Okay, so
Okay.
we have a student who has asked, for starters, do you recommend entrepreneurs to self-learn about the legal side of their proposed business, or should they hire or collaborate with others for that side of job?
There's a saying that a little bit of knowledge can be very dangerous. Sometimes there's certain things that you can read up on, but I think if you're trying to avoid a pitfall, it is always safest to start out right. I would like to think that the law is very, very complex. You might think the top layer, but it just goes really, really deep, and anything can go wrong along those layers. So I would say that you know get the right advice early.
Okay, all right. So getting the right advice early. Okay. And moving along from there, we have another interesting question here where the student says, if I were to build a startup on Web 3.0, how would the legal issues pan out as the crypto industry has not yet been regulated very well by the government?
Well, if it's not been regulated by the government, there will be other applicable laws and regulations, right? And if it's not regulated to the point that the government is not going to allow it, then you probably can't do it. But if you can already do it, then you don't need to wait for any specific regulation by the government. There will already be applicable laws and regulations which your lawyers would advise you on, because they would know, generally all the other applicable regulations.
Just to top up a bit on this, so that perhaps this would also be if you are doing business in a country that recognizes cryptocurrency or the usage of cryptocurrency, as well as a country that does not yet do so, that would mean that you would still have to make sure or ensure that there is synchronization in the processes that you run so that the target market is not affected by this. Would you agree to that?
Yeah, synchronization, I think, is something we spoke about earlier. That is always going to be required. If you're talking about usage of it as a currency, yeah, if it's not recognized in a certain jurisdiction, then you just can't do it over there. But if over here, let's say you can, and you've got general legislation or regulations that cover this kind of transactions, then that will still apply, even though you don't have specific guidelines to address that particular transactions.
Okay. So for the student who has asked this particular question, based on what Pam has advised us, this would be something that you always have to go back to the legal expert to gain 100% confirmation on.
Because there might be some other aspects that are applicable in the regulations that you may not be aware of.
Duly noted. Okay, so moving on to the next question, we also have here. It says, if after starting a business, then we felt that the logo isn't suitable for the business we've done, and if we change it, is it going to affect the salary or services, although the business is successful?
Salary and
It's
salary of
interesting.
staff, do you mean? The salary of staff would be your employment contract with them. You can't just change it as and when you like, right? Because that's a contract that's firm. You'll have issues with labor laws if you do that. Um, Sorry, so if you have a logo that you have already trademarked, I don't think it's very expensive to trademark a logo actually. So if you don't
No.
want to use it anymore, you just, so initial trademark is the license is for 10 years. If along the way you don't want to use it anymore, you just let it run its 10 years and you come up with a new logo, you re-register that, but your business is still running, right? So as long as your business is running and you have your staff, you need them, you still have to pay them, unless you terminate the contracts the right way. Because in Malaysia, employees have vast rights,
Right.
unlike Singapore, Hong Kong, US. So be very careful about what you do with your staff.
Okay, so I'll just probably expand this a little bit. Let's say it's a product that we're doing and it's prehistoric. Let's say, for example, again, the same, we are moving along the same lines where they find that the logo is not suitable, and they've decided to make amendments or changes to it, but they wish to still maintain the business model as it is. The only thing that they change is the logo. That's perfectly fine
Yeah.
to do. You can still
Absolutely,
do.
because the first logo is yours, and what you want to change it to is still yours. Whether you're probably you'll have to do a research on the psychological aspects to see whether customers are going to love this logo better than the other logo because it's connected to someone else who's I don't know. But yeah, both are yours. You can do it, but again, you need to register your new logo and follow the same steps so that you don't transgress on other people's IP rights.
So I guess it's another situation of trial and error or a catch 22 where,
Yeah,
again, depending on how aesthetic experience is basically where the product is concerned.
true.
Okay. Okay.
So a lot of
All right.
R&D normally, right, when you're coming up with something.
Yes, a lot of R&D. That's right. Okay,
Good,
so
you've
we've
got some
got
very interesting questions.
some very interesting questions. Yes, and more are coming in actually. So if I may move on from there. A student says an idea or a function implemented by software may be patentable, but does this mean that all research and development carried out in the field of software is patentable?
What is patentable is a product. So as long as something is a product and it's different from what anyone else has done, you can patent it. So all IP is all about producing something, right? That you have rights over.
Okay. All right. So it's quite a straightforward thing actually.
Software normally is more, I think, is the source codes that you would copyright.
Hmm.
You know,
So
yeah.
if you had to choose between either protecting it by copyright or by patent where software is concerned, would you actually recommend more of a copyright process rather than a patent? Or would
I
it
think
depend?
software is copyright. I don't think software is it's something that you can patent.
Okay. And that is
Yeah. So,
primarily
but
because
like I said, I'm not an IP expert. I've just dealt with it on the commercial side, so I know
Mhm.
that I know some portions of it, but exactly what is patentable and all that is that's you got to see an IP lawyer to advise you. But from what I know, software you get the source codes, and it's the source
Mhm.
codes because it's something that's you know printable. Then you
Yeah.
copyright it.
Okay. All right.
Okay.
So where software is concerned, it is more appropriate to copyright rather than patent. Okay. Okay. So moving along from there, sorry. We have another question here that says, what type of penalties could I incur if I infringe on someone else's intellectual property rights?
You see, the suit that they would bring is at the end of the day, they're claiming damages and they'll have to prove there's no set cost of, if you transgress this is how much you're going to pay. It's a matter of how much they can prove in court that they have suffered as a loss. And that would depend on how big their business is, how much they have lost, or what's the impact to their business. And it'll be, left to the judge to decide based on everything he hears as evidence. Okay, so it could be a lot. And if it wasn't so much, he wouldn't have spent money on lawyers to file a claim, because when you first have someone transgressing on your rights, you're going to think about that, right? So
Correct.
for instance, I've had a motorcycle, knock into me, and it hit my bumper a little bit. Then I'm going to think, oh, it's definitely his fault. Am I going to sue him? I'll probably think, nah, I just have to spend 1,000 ringgit, get this bumper sorted out. No point suing him and seeing a lawyer because I'll have to pay more, right? So it's
Yes.
something like that. You actually have to see what is the damage that they would suffer and whether it's worthwhile them bringing an action to court. For McDonald's, it was. I don't know why they thought that, McCurry would infringe on their rights or goodwill, because if you want to eat a burger, you go to McDonald's. If you want to eat curry and rice, you go to McCurry, right?
That's right.
Yeah.
And it's quite interesting because McCurry is actually it's just a standalone. It's one individual or organization, small organization that is running that kind
It
of
was very
business.
small at that time, yeah. But I don't
Yeah.
know. I heard it's got a franchise now. I don't know.
Oh, okay. Okay.
I'm not
But
sure.
at the
they've
time,
become they've become so popular with this that I think they should thank McDonald's for it.
so maybe that is something that we'll probably have to explore as a case study to see
Yeah,
what
it
did
should be
they do
interesting.
and
I
what
think
are
they
the
came
right.
up with other Macs later on, in other territories like McNoodles or Mac something. I don't know what it was.
Okay. Okay,
But they did
interesting.
succeed in Philippines with
Mm.
McJoy. I can't remember the facts of that, but McDonald's did succeed in Philippines.
Okay, so definitely something that I'm going to research on and explore a little further
Yeah, if you
to
can't sleep tonight, just
go
search
into.
these things.
I will do just that. I will do that. Okay, a few more questions, interesting questions that we have, Pam. Another one here says, how similar can your company's name be to another company? It's a very straightforward question, but a
Yeah,
good one.
so yeah, it's interesting, right? So I've come across
Mm,
Panasonic and Panasonic, and I'm still trying to
yes.
figure out whether it's the same thing, And at first I thought, no, it can't be the same thing. It's so obviously different in spelling. Then I thought, but it's been around for so long. How come Panasonic hasn't done anything about it? And because it's been still there, it must be the same thing, right? I've not been inquisitive enough to do that search, but this is one of the ways that, um, you could get fooled, right?
Yes, that's right.
Yeah, that's the
Um,
only example that comes to mind.
So in that respect, I mean, you have raised a very good example because definitely Panasonic and Panasonic it's similar. So are we saying in response to this particular question, are we saying that although it's similar yet it's different, it's acceptable? Because when we look
You
at
see,
it, the
when you
kind of products that they sell is pretty much.
Yeah, products are the same. So if I I don't know, you see so Panasonic has been there forever in every country probably, and if
Yes.
Panasonic is coming in, it's a Malaysian brand. Like I said, if they were smart, they would go and register first. When they try to register, the registrar will definitely ask them all these questions, right? You're so similar to these people,
Hmm.
and the same, you're going to register the same classes, right?
Yeah.
So there is the niche classification, you've got a lot of 52 classes there. If the
Mhm.
products are similar, you're going to want to register in the similar classes. And then the registrar is going to say, oh, wait a minute, I'm not sure I'm going to allow this. So if Panasonic has been registered, I'm quite curious to know, how did they differentiate it, and
Could they have
what ground.
potentially come to a negotiation with each other that allows them
Possible.
to,
That's
have
possible.
competition?
That's possible, so they can say, all right, I'll allow you to carry on, but you tweak your logo a little bit and you focus on these products and I'll focus on these. I'll do,
Mhm.
washing machines and dishwashers, and you do fans and TVs or something like that. It's possible. But Panasonic is, such a big brand. I
Right.
doubt they're going to let someone new walk in and just sweep up half their business. I don't think so. I'm not sure. I don't know what happened at the back there. For all Panasonic just hasn't done anything, and Panasonic doesn't feel that they're a competitor at all, and they don't want to waste their money.
Possible, possible. So aligned with this particular question, or the answer is that it would depend on the situation. Basically, it depend on what exactly the name is and what they're doing and things like that. So advice would be provided on a case by case basis, I
Yeah,
suppose.
definitely.
Okay, very well. Moving along from there, another. Let's see. Question. This is pretty interesting. Something out of the ordinary, actually. It says, if I use someone else's slogan or pictures and give credit also, would I still be charged with copyright?
Uh,
I think
Slogan, yeah, if they have registered it, I think I did cover that. Slogans can be registered. Um,
because I think if I may actually just fine tune this question a little bit, it possibly could be a situation where if you have images or you have a slogan that has like shutter shop stated across it, or it has the identity of who it belongs to mentioned. I presume this particular student is asking if they were to use that kind of image, would they be charged for infringing copyright?
I think when it comes to image and all that, it's also personal data, and I think I'll be very slow to use people's images.
Mm-hmm.
When it comes to slogans and things like that, I think whenever you're in doubt, try to find out who's registered what. You can always approach them, or you could. I think for copyright, for instance, if you're doing a thesis, for instance, and you are referring to a certain part taken from a certain textbook, then you just give credit to the author. That's what they normally do,
Okay.
right?
So always best to play it safe by giving acknowledgement.
Yeah,
Okay.
that's
All
right.
right. Okay, we have got another interesting one here where it says, if there is a similar product in the market, but not exactly the same, can you patent it? How much percentage of product should be different or similar to an existing product to be patented?
Okay, I'm not really an IP expert. I would ask you to, get some advice to see how much. But largely, when it comes to patents, you're actually an inventor. You've invented something that's totally different and useful and things like that. So there are some prerequisites that you have to meet.
Okay. All right. So again, it goes back to the basic rule
The
that
facts, yeah.
yeah, you need to look into that and then go to an expert to get the right advice. Okay. So I believe that pretty much sums up our questions. Some of them seem to overlap. Some of the questions we have actually addressed during our session as well. So, with that, Ms. Pam, thank you so much for taking the time to explain about commercial as well as intellectual property issues that we should be aware about, and how we can actually continue to evolve and develop as you know we move along in the realm of entrepreneurship. So with that, would there be anything further that you would like to share with us?
No, I think I just want to remind all of you, lawyers are human beings. Don't be afraid, right? See them early and buy them teh tarik, and they will give you a lot more free advice. or they'll throw in a lot more things than you actually need to pay for.
Right.
Thank you for having me. It's been really nice, trying to give you whatever advice I know. Thanks again.
Thank you for that as well. Thank you so much for the insight. If I may take to the floor, just a couple of announcements that I would like to identify to our students. We have got two QR codes for you to scan. All right. The first one that is coming to your display will be the feedback QR code. So if you may take a few moments in order to sign in or tune in into our survey, that would be wonderful. The second QR code that comes your way will be for your e-certificates. So if you may just take a moment to scan it, we would appreciate it very much. With that, ladies and gentlemen, thank you very, very much for your time. Have a pleasant evening.